Good morning, good afternoon, good evening, depending on your time zone. My name is Fikri Faruqi, and welcome to the session. And welcome to the session on the Legal Roundtable, assessing the implications of the ICJ and other climate advisory opinions for the private sector, hosted by the Brazilian Bar Association of the Environmental Law Commission, Tauil, Chequer, Amir Brown, the University de Caxias do Sul, UCS Brazil, the International Bar Association, the American Bar Association, and the British Institute of International and Comparative Law, BIICL, during the 2025 UNFCCC COP30 Climate Law and Governance Day. Thank you for joining us. I will hand over the floor to our chairs, Professor Alessandra Lehmen and Dominique Hogan-Doran, SC. Thank you.
Thank you so much for the introduction, and good afternoon from Brazil. I am Alessandra Lehmen. I am co-chair of the Climate Law and Governance Initiative. I am a law professor at UCS in Brazil. I am also president of the Environmental Law Commission at the Brazilian Bar Rio Grande do Sul State Chapter. And it's an absolute pleasure to co-host the session today, which will discuss the recent advisory opinions on climate change and their repercussions for the private sector and their lawyers. Briefly, to set the stage for our discussion today, I just wanted to start by saying that 3 international or regional courts have recently issued advisory opinions on state obligations with regard to climate change. The International Tribunal for the Law of the Sea, the Inter-American Court of Human Rights, the International Court of Justice, and a 4th one is also expected soon from the African Court of Human Rights. So although these decisions are non-binding in nature and they are, of course, directed at states, we can anticipate several relevant repercussions for the private sector, which in turn prompt corporates and their lawyers to follow these developments closely. So I would like to kickstart the discussion by highlighting very briefly 3 points. First is the ICJ did not recognize direct corporate obligations, or neither did it elaborate on extraterritorial regulation or specific legal consequences for states' failure to regulate private actors. But the ICJ did note that a state may be held responsible for failing to regulate private actors' GHG emissions, even if the conduct itself is not directly attributable to the state. The second point that I want to highlight before we hand the floor to our distinguished panelists today is the decisions recognize the normative content of the Paris Agreement, Article 4.2, in the sense that states have a due diligence obligation to implement domestic mitigation measures, including for private actors. And finally, state obligations, my third and last point by way of introduction, is that state obligations extend to regulating private sector activities that impact areas beyond national jurisdiction. So environmental impact assessments, for instance, for private activities must consider downstream climate impacts, even if those occur in other jurisdictions. With these comments and without further ado, I now have the pleasure of giving the floor to my co-chair, Dominique Hogan-Doran, who represents the IBA Bar Issues Commission Regulation Committee, who will introduce our stellar panel of experts joining us today to discuss these implications. Dominique, over to you.
Thank you so much, Alessandra. Yes, we've got a large panel, so I'll move through us quickly and then reintroduce as we go through our questions. I welcome today Leonardo de Camargo Subtil, who's a professor of international law and a former president of the Brazilian Institute for the Law of the Sea. Ana Chegas is an officer of the IBA's Water Law Committee and a lawyer. Luis Gustavo Becerra leads the environmental and climate change practice, and he is also a climate change law and carbon market regulation professor. Caroline May, a partner at global law firm Norton Rose Fulbright, who chairs the Climate Change Committee of the Law Society of England and Wales. Dr. Ivana Elogna is a senior research fellow in environmental and climate change law at the British Institute of International and Comparative Law, where he leads the global toolbox on corporate climate litigation. Mariana Herrera is a partner co-leading the Environment and ESG Practice Group in Mexico City and serves as the Vice Chair of the IBA's Water Law Committee. And John Dernbach, an Emeritus Professor of Law at Widener University. And finally, Patricia Campos Melo, a Constitutional Law Professor and Public Attorney in Rio, which I'm sorry not to be in Brazil, but I'm glad that so many are today and this week for such important work. We start with our first segment of our discussion today, and I'll be inviting Louise and Anna to lead us off. And our question is this: how do you expect the opinions to shift corporate climate governance and strategy? And if you consider what are some of the legal tools we expect to see emerge in the private sector that are going to manage these shifts and changing risks?
So I believe I was listed as the first one to talk. So hello to everyone. I'm talking directly from Belém, from my hotel room in Belém. So it's great to be here to see Brazil moving forward with the climate policy worldwide. I would like to thank Alessandra Lehmen for the invitation. I would like to compliment all of my colleagues here. I met Professor Caroline May in London some time ago. Ana Paula Chagas is a great friend. Many of you that are here are friends that we currently met in different occasions. So it's a pleasure to be here in this Climate Law and Governance Day, which became a huge tradition in COPs already. So it's really a pleasure to be here for the first time. So directly answering Dominique's question, what I could say to start with is that these opinions make it much harder for boards to ignore climate change. So they, of course, we have companies in different levels of maturity in terms of climate governance, but now even the ones that don't have the maturity to deal with climate governance, the boards are not able to ignore climate anymore. Another thing that I believe is a consequence of the advisory opinions is that climate transition and physical risks are now clearly legal and human rights risks. So this is also indisputable. It's not only talking about financial risks as some defended in the past. And finally, now I believe that courts in general in several jurisdictions may be more willing to read duties of care and loyalty in light of this emergent international baseline, what we can say from these advisory opinions. So I believe this will have many consequences and several consequences to corporate and climate governance for corporations in general. Talking about Brazil, I believe it's useful to see how Brazil is behaving. I would start by saying that in Brazil, companies are in a high level of maturity in dealing with climate governance. We already have a lot of regulations in Brazil for some time, and we even have some very relevant precedents, even from our Supreme Court. So I believe many of you should know about a constitutional lawsuit that was decided in mid-2022 from Minister Barroso, who now retired from our Brazilian Supreme Court, in which he decided that the Paris Agreement has a supra-legal nature, supra-legal status, and therefore should be taken into account by federal entities in Brazil, states, municipalities, and even the federal level. So we have been seeing, even before this decision, but with this decision much more, regulations popping up in every federal entity in Brazil at the state, including at the state and the municipal level. And of course, this also sets the grounds for in Brazil, we have a very new carbon pricing public policy. We have a law for our emissions trading system. So Brazil approved less than 1 year ago the new law for the Brazilian ETS. Of course, it's a long way to implement this ETS, but it's a powerful public policy in which companies are called to pay attention to the pricing of carbon emissions. So they will be bound to this new emissions trading system that will operate in a couple of years. I'm hugely involved in the implementation of these new laws, and I believe this is a trend that we see globally. Public policies on carbon pricing, being carbon tax or emissions trading system, that make corporations to see very clearly and they treat very seriously climate governance, dealing with their emissions, reducing their emissions, and building their emissions reduction strategy. And I would say that I know that we have a litigation session in our discussion this afternoon, but I cannot leave without mentioning that we have already had a very relevant decision from Judge Rosa in the south of Brazil. It's a decision from the 22nd of August this year. So the ICJ advisory opinion was published in the 23rd of July, as a coincidence, my birthday, my 45 years birthday. And less than 1 month after that, on the 22nd of August, there was a ruling at the first instance court in the state of Rio Grande do Sul, where Alessandra sits, that hugely relied on the advisory opinions. So expressly mentioned the advisory opinions and hugely relied on the advisory opinions. We, as a law firm, were involved in this case. It's the Instituto Preservar Herol versus Eletrobras. So we were representing Eletrobras in this case. Of course, we say that there should be caution about the consequences for corporations in other jurisdictions. They should assess the litigation risks tailored with each jurisdiction. But in Brazil, we already have a huge trend of climate litigation against corporations. I believe they are reinforced by the advisory opinions, and this specific case already mentioned all of the 3 advisory opinions. This ruling from August 22 determined mandatory climate impact analysis, environmental licensing for thermoelectric power plants in Brazil. So it relies a lot on the advisory opinion from 32
Wonderful.
to
Thank you,
35
Louis.
from IACHR, and it also mentions ICJ and Intl's advisory opinion. So
Thank you.
Thank you, Louis.
You're over time already.
We're conscious
but,
of time, Louis.
We put you on the spot by being first.
I invite you to read this 98 pages sentence from Minister Rosa.
Thank you so much, Louise. Anna, could we go over to you for your thoughts and contributions? Thank you.
Promise to be brief, okay? But first of all, I'd like to say hello to Dominique and Alessandra. It's a great pleasure to be here today with the all-star colleagues in this panel. And so Louise just brought a solid overview of what these advisory opinions mean for companies. So the governance impacts and the litigation risks. But I'd like to take a step back and to take a different path. I want to bring to you how these opinions reshape the legal landscape and what this means not only for companies, but also for lawyers and for bar associations around the world. So over the past 2 years, something important has happened. So the ICJ, IT laws, and the Inter-American Court have all sent a similar message that climate deaths are not only political promises, they are legal expectations. And even though these opinions do not regulate companies directly. They will influence how judges think. So, and they will influence how regulators will write rules from now on, and how lawmakers will raise national standards. So they create a new reference point. It's a kind of a global guide connecting climate impacts with human rights in a much clear way. And when that connection becomes clear at the international level, it spreads quickly. If states must act with more ambition, if they must regulate private actors more closely, then companies will naturally face higher expectations too. But there is another part on this history, a part that will affect all of us in the legal profession. So what we see that is the climate issues have moved, and they are no longer limited to environmental teams anymore. They will appear and they will be mandate in corporate governance, in finance, in supply chains, and in consumer protection, and of course in litigation. And this means something very simple. Lawyers will need to understand climate risks the same way they understand financial risks, not in scientific detail, but enough to guide boards, write better contracts, and help companies make informed decisions. This is the real shift in the way we practice law. And this is exactly where the IBA plays an essential role. Bar associations everywhere are trying to keep pace, and the law is moving really fast. And the bar associations need to support our profession. And the IBA works to translate these international messages into something practical. Oh my God. Something that bring lawyers to give a clear advice and better model clauses and a more accurate risk assessment. And we also work closely with National Bar Association. And this is an important part of the role that IBA plays in the international landscape. Because the climate rules will develop in different levels and speeds in different countries, but the underlying principles are global. So we will help build shared understanding and common standards, so lawyers in different regions are not working in isolation or confusion. And another point that we must consider is that the advisory opinions all point in one direction. It's a stronger action and more accountability. So lawyers must not wait for a crisis to start advising clients. We need to advise early, and we need to help companies anticipate what's coming and not just responding when something goes wrong. Now, from the company perspective, the tools you heard earlier remain essential. So they need better governance, climate clause, clear disclosure, supply chain checks, and to make that climate risks take parts of their strategies. And so companies need to act in line with science. And the ones that don't act like that, they will be seen as responsible. So the companies that don't, they will be asked also to explain why they don't act like that. So in many ways, we see that the burden of explanation is shifting. And if a company's strategies does not match the risks we all know all about, the question becomes why not? And the final point that I'd like to bring to you is that for company, climate choices are becoming strategic choices. And for lawyers, climate knowledge has become a core skill, not a niche area anymore. And for the IBA and for bar associations everywhere, the task is clear that we need to prepare the legal community for this new moment. We need to offer clarity training and guidance so all the lawyers feel ready to face these new challenges. So
Thank you so much, Anna. So just recapping, and you've raised a number of points that we'll also take up further discussion later in our session today about what bar associations and lawyers can do. But it's clear, isn't it, that companies are going to have to adapt their governance contracts and their climate disclosure to anticipate the litigation and regulatory shifts that come from and are compelled by these advisory opinions. And there is going to be a need for an increased focus on things like ESG clauses, sustainable finance arrangements, and supply chain due diligence in order to advance corporate climate ambition. I think we might then turn back to you, Alessandra, for looking at this sort of litigation risk exposure that companies are now exposed to. Thanks so much.
Wonderful, wonderful. Thank you, Dominique. And it was great to hear from my friends, Luis Gustavo and Anna. And before we start our discussion on litigation, I want to echo what Anna just said and say that climate risk is financial risk. So I think we're way past that false dichotomy between climate risk and financial risk, which has dominated the legal discussion for a while. So without further ado, I would like to introduce the second part of our panel today, and it's which will discuss the impact of the opinions on corporate climate litigation risk. Luis has already introduced the matter in his introductory speech. So now I would like to turn to Ivano Alonha and afterwards to Patricia Campos Melo for their remarks on climate litigation and the impacts and repercussions of the opinions on climate litigation risk from the perspective of corporate actors. Ivano, the floor is yours.
Thank you very much, Alessandra. It's a pleasure to be with all of you. So, without further ado, the advisory opinion, we understood, marked really a real turning point for corporate climate accountability in international law. While these advisory opinions are not legally binding, they carry strong legal weight and moral authority because they interpret and clarify existing obligation of states. So together they form a new body of international climate jurisprudence, and these directly affect corporate litigation risk by validating, accelerating, strengthening also major trends. We already see in strategic climate litigation. This is something that we are doing at BIICL with, as you said, the Global Toolbox on Corporate Climate Litigation. In many ways, these kind of opinions help address what's being called the glaring gap in corporate climate accountability. And so I will try to briefly highlight how these opinions fit within the broader litigation trends. So, as I said, a first contribution of the advisory opinion is that they provide new normative and legal tools that support the global rise in case targeting private actors. At least this is what we always hoped. A core element in all the three advisory opinions is the clear statement that the state's international obligation extend to the regulation, supervision, and control of private actors, especially companies whose activities generate greenhouse gas emissions and harm the climate. So just on all of them, Intl states explicitly that the duty to prevent marine pollution applies to activities under state jurisdictional control, whether public or private. States must therefore regulate private entities whose emissions contribute to climate harm. The ICJ confirmed that its inquiry includes the action and omission of non-state actors that fall under state jurisdiction or effective control. And then the Inter-American Court. This goes even further and recognizes that companies also have obligation and responsibility of their own regarding climate change in its human rights impact. State must give practical effect to these responsibilities through domestic regulation. So this convergence reinforces what we see in domestic litigation. In 2024, around 20% of climate cases targeted companies or corporate officers. So a very important trend that keep improving. Second, all the three opinions frame states' climate duties as due diligence obligation. They set a very high bar. So first, ICJ and ICJ stress that because climate risks are severe and irreversible, the standard must be particularly demanding. The Inter-American Court goes further again, developing the idea of enhanced due diligence, which integrates human rights. And meeting this standard means states must adopt ambitious, proportionate measures, especially regulating corporate conduct. And the Inter-American Court lays out a framework for this, requiring, as you've seen, companies to conduct due diligence of both climate and human rights impact across their full value chain. We'll see. Crucially, the ICJ identified that if states failed to regulate private actors' emission, this could amount to an international wrongful act, and the links corporate regulatory failures directly to state responsibility. So another trend is the third, reinforced by the advisory opinion, concern fossil fuel financing and licensing. So the ICJ states clearly that failing to regulate fossil fuel production, fossil fuel consumption, exploration licenses or subsidies may breach international obligation because these activities overwhelmingly benefit private companies. This gives activists and civil society a strong new argument in domestic courts when challenging state support for corporate fossil fuel expansion. We see that this already started somewhere. Fourth, the opinion also supports litigation strategies aimed at multinational corporate groups. So the Inter-American Court urges states to consider the structure of economic conglomerates and transnational corporations so that legal responsibility can be attributed to parent companies or entities exercising control over subsidiaries and affiliates. And it also requires companies to disclose greenhouse gas emissions across their entire value chain. This directly supports transnational cases brought in their own jurisdiction of multinational corporations, where enforcement may be more effective. And then the last, finally, the advisory opinion gives strong backing to climate washing cases, which at this point remains the most common form of corporate climate litigation, the one that since I think 5 years have been the one that has been more broad and also the most successful. So the Inter-American Court requires states to adopt standards to prevent greenwashing and to protect climate policy making from undue corporate influence. And this bolsters climate policy making and ongoing litigation challenging misleading or inaccurate corporate climate claims, especially in light of the scientific evidence that misinformation can deepen polarization and delay urgently needed adaptation measures. And this is another very interesting trend that we are seeing developing even in Europe. And to conclude, if international climate law was once a loose fishing net, held only by states, then the advisory opinion have acted like a forge. They've hammered that net into a tighter, stronger legal framework. The old gaps in the net, sorry for this metaphor, like quick standard regulatory loopholes, used to let major emitters slip through. And by now, new legal strands like enhanced due diligence, fuel value chain disclosure, differentiated duties for carbon measures, this is also very interesting, make the net much more effective, or at least we hope so. And with this reinforced framework, domestic litigators, our fishers, have a better chance of catching corporate polluters and holding them accountable. And I thank you for your attention.
Thank you very much, Ivano. I definitely agree with your statement in the sense that the ICJ opinion and the opinions in general establish a moral imperative with regard to climate obligations for the private sector, and also besides the moral imperative aspect, the ICJ also framed in no unequivocal terms the underlying obligation as erga omnes in nature. So the legal significance of the decision is also particularly acute in this regard. Without further ado, Professor Patrícia Perrone Campos Melo, the floor is yours for your considerations. Thank you.
Good evening, everyone. It's an honor to be here. Can you hear me? Yeah? Okay,
Yes,
so I think I'll focus on the impact of the opinion, especially at the Superior Courts of Brazil, especially at the Brazilian Supreme Court. I've been there for 11 years, and so I've seen the court acting on these cases. Well, for the Brazilian Supreme Court, comparative law and international law is quite important in general, and especially on climate litigation. The court has a way of reasoning that considers other courts' decisions on the issue to decide its own cases. Comparative law is considered to be argumentatively important, especially if the decisions were delivered by very respectful courts in Latin America or international or European courts, American courts, etc. So comparative law is quite influential in Brazil. We also treat as comparative law the international European law, the international African law. What means that we consider in our reasonings the standards they affirm in order to justify our own decisions. In what concerns to our international regional law, the decisions delivered by the Inter-American Court, the opinions delivered by the Inter-American Court, although this is a discussed issue in Brazil, and although the country has been quite resistant to that in the past, Brazil is starting to recognize that inter-American precedents on the subjects the courts decide are binding. That means not only that it is obligatory for Brazil to comply with the inter-American decisions on cases in which the country is a part, in which he's answering to the action, to the litigation, but also Brazil has to consider as binding the decisions delivered by the Inter-American Court whenever it is not a part of the case, but since the court is defining standards for the whole region, for all the countries of Latin America who submitted to its jurisdiction. So what that means in what concerns to climate litigation is that for the Brazilian Supreme Court, all the content recognized as obligatory by the Inter-American Court will start to be considered by the Brazilian Supreme Court as an obligatory standard, as an obligatory binding precedent for the state and for private companies in general. So this is really changing the way and the content in which we decide from a substantive point of view and from a procedural point of view. Brazil has already been developing a new way of dealing with these with climate litigation. It's been trying to develop has been called structural litigation procedural law, because since we have in Brazil a problem with the judiciary intervening too much in public policies, the court is trying to develop these litigation procedures in another way. Instead of delivering decisions that say what the state, the public, the government, or the company should do, they invite all the authorities responsible for guaranteeing that the legislation is complied with to negotiate and to present a new formulation of a new public policy whenever the public policy is not working well. The court defines some issues that should be part of the policy, and afterwards the court also supervises the implementation of the new policy. So from a substantive point of view, the decisions are quite influential. The Latin American, the inter-American ones are binding. The other ones are very relevant from a reasoning, for the reasoning of the Brazilian Supreme Court. And from a procedural point of view, a new kind of structural procedure is being developed so that the way we deal with this kind of litigation will be more effective. That's it.
Thank you very much. Thank you very much, Patricia. I am told we are actually ahead of time, which is quite surprising for a panel of lawyers. I want to briefly comment before I hand it over to Dominique for our final session and Q&A. I would like to comment very briefly on the subject that Ivano just touched on the possibility that the advisory opinions will raise even more cases, will serve as basis for even more cases of a transnational nature. And this is a phenomenon that we've been witnessing with regard to climate litigation in the past several years, not only because we have seen a flourishing of norms and regulations which are transboundary in nature and whose effects span several jurisdictions and encompass global value chains as a whole, but also because I believe climate change, both the scientific and legal narratives concerning climate change are truly global, and the object of climate law is truly diffuse. So that's one point I wanted to bring up. And the second point with regard to Patricia's intervention, Patricia was High Secretary of Studies in the Supreme Court until quite recently, last month, I believe. And she worked closely with Justice Barroso, who also until his retirement last month served as president of the Brazilian Supreme Court. One of the things that I would like to highlight in terms of procedure, because Patricia's intervention also touched on procedure, is that the very first climate case to reach the Brazilian Supreme Court, a DPF 708, or more widely known as the Climate Fund case, also innovated procedurally in the sense that Justice Barroso determined a public hearing, which took place in all of 2 days, in which 66 experts were heard in order to help the court build their understanding with regard to not only legal aspects of the case, but also the underlying science and economics aspects, which are, I think it's a welcome sign when we see this the intention from judges to duly integrate those considerations into their rulings. So thank you again to my friends Patricia and Ivano for their brilliant interventions. And so Dominique, over to you for our last segment of today's panel, and we hope we'll have time for Q&A. We already received several quite interesting questions from the audience, and we want to make sure our panelists have time to answer to at least a few of those. Over to you, Dominique.
Yes, well, we've gained a bit of time because I've restricted my comments because I've got quite the lurgy cold from after just returning from the International Bar Association's conference in Canada, back here in Australia. I'm going to turn now to John Durback and to Carolyn May and picking up on Anna's comments from earlier. For us now to consider what role do bar associations and law societies play or need to play in equipping lawyers to advise clients, particularly corporate clients, on the implications of these opinions. John, you've done a lot of work in this space for a long period of time and you have a lot of insights. Over to you, if we may.
Well, thank you, Dominique. I'm going to describe what the American Bar Association has done and is doing to address climate change and sustainable development in law practice. This includes, but is not limited to, the impact of recent ICJ and other international climate change decisions. In 2019, the American Bar Association's House of Delegates, its chief policymaking body, adopted a resolution urging lawyers to advise their clients of the risks and opportunities that climate change provides. The resolution also urges lawyers to engage in pro bono activities to incorporate, to reduce greenhouse gas emissions and adapt to climate change. In 2024, the House of Delegates adopted a resolution on sustainable development. It urges lawyers to learn about sustainable development and to counsel their clients on related risks and opportunities. It also states that the ABA should provide resources such as educational materials, practical tools, training programs, best practices, and guidance to assist lawyers to incorporate sustainable development into their law practice and pro bono activities. A critical point here is that both resolutions are not simply about counseling clients on compliance with existing laws. They're also, and you've heard this from other speakers, about counseling clients on the many risks, physical risks, reputational risks, transition risks, and others that are associated with climate change. And they're also about the opportunities, such as cost savings, community support, competitive advantage that climate change and sustainable development can bring. This means there's important work for lawyers to do regardless of national politics and changes in national laws, and recognize that I'm speaking now from the United States. The recent ICJ and other international decisions on climate change underscore the continuing importance of climate change and sustainable development legal work in the U.S. After passage of the climate change resolution in 2019, the ABA established a climate change task force that meets every several weeks to discuss ABA policy and to figure out things that we need to do next. In particular, the ABA is now an accredited observer at the Conference of the Parties of the Climate Change Convention. I'm wondering, as I speak, how many other national bar associations are observers. ABA has sent delegates to the COPs since 2021. This year, we have both actual and virtual delegates at the COP in Belém. Among other things, this provides us an opportunity for learning and sharing. We now have regular online meetings with colleagues at the International Bar Association, the Brazilian Bar Association, and other law associations to plan shared events and exchange information about current activities. We learned about the Law Society of England and Wales climate guidance from this effort. And internally, we now provide a regular briefing on climate news to the ABA president. After passage of the sustainability resolution in 2024, we set up two task forces. The Law Practice Task Force, comprised mostly of legal practitioners, has organized and continues to organize informational webinars about these resolutions and other climate and sustainability topics relevant to practicing lawyers. This includes the recent international climate change decisions. The task force is also developing a practice note, providing about 25 to 35 pages. We're hoping it will land in about that length, providing practical guidance to help lawyers advise clients on the evolving standard of care in construction and real estate transactions, and common challenges in legal precedent shaping liability exposures and their professional obligations in the climate change context. It's really important for lawyers to recognize that the standard of care in this work is evolving to take climate change risks into account, and practices that were once good practices now pose a significant risk of liability for clients. The second task force, the Legal Education Task Force, is comprised of classroom and clinical professors. It is collecting information on law programs from around the world on teaching climate change and sustainable development. And I'll just give a shout out that a lot of the very best work we've seen is from Australia and New Zealand. A major theme reflected in many of these programs is teaching these subjects across the curriculum and not just in specialized classes. And this is particularly relevant to the topic today. In U.S. law schools, students interested in environment or climate typically take classes about such topics as elective. Typically, too, students who are interested in corporate and business law do not take such classes. As a result, a great many students graduate from U.S. law schools without having received any legal training concerning climate and environment. And this includes a great deal of students that decide to work in business or corporate law. A major challenge, of course, in teaching such topics across the curriculum is how to add such information in classes without subtracting other important information. We are setting up a resource webpage that lists or provides links to work that is already being done. As I said before, colleagues in Australia and elsewhere are also already teaching sustainability and climate change across the curriculum. Some U.S. law schools have specialized classes that focus on the climate and sustainability aspects of business and corporate law, such as ESG. And we're preparing a detailed explanation of the need for this work that will be available on the website. We're happy to share what we're doing and to hear your suggestions about what more we should do. And I hope this is helpful to folks as a source of ideas. Thank you.
Thanks so much, John. We'll go over to you, Caroline.
Thank you. Good evening, good afternoon to everybody. I've got a few comments to make about the ICJ and the advisory opinions, first of all, and then I'll talk about the work of the Law Society of England and Wales, which John has kindly given a shout out to. So the ICJ and other advisory opinions help to reinforce the scientific fact of climate change, which is somehow getting drowned out in certain parts of the world with the geopolitical influences that we're hearing. So it was very refreshing to hear about the work of the American bar in this context. So they help to reinforce the scientific facts of climate change. They're obviously voluntary and they have transboundary impacts, which I think is helpful both for developing principles of international law. It helps provide jurisprudence for courts, maybe in parts of the world where this area of law is still emerging, and it helps refine decisions in the more developed jurisdictions. So I think it also helps, as Ivano said, it encourages and enables group claimants and those who often don't have a voice through using the legal profession to bring claims and to make challenges against large corporates and large institutions where perhaps they wouldn't have a voice otherwise. So I think and anticipate and enforce what Ivano said about the growth of group litigation. In the UK today, we've seen handed down the largest ever judgment in the BHP case involving the Fundão Dam in Brazil, 620,000 claimants, the largest group litigation the English courts have ever seen, and that's tracked its way to the UK courts because of corporate headquartering. And we've seen quite a number of cases of that sort. My own firm recently handled a reparation fund claim, which was brought against two larger European financial institutions using their own independent complaints mechanism from their own ESG policies, where claimant groups then were able to bring challenges and claims which actually avoided litigation but led to the institutions themselves setting up a reparation fund to restore some environmental benefits to the indigenous communities who'd been affected by the large infrastructure project. So I think the benefit of these international jurisdictions is it gives a voice perhaps to those without one, and the role of lawyers on both sides of that debate is to help refine and to sort of tease out the legal arguments. So there is a role for this profession, not just for the law, but for the lawyers acting on all sides. So in England and Wales, the Law Society of England and Wales in 2021 recognised that it hadn't actually adopted a position on climate change. This was when COP was coming to Glasgow, and therefore the Law Society, in response to concerns from its members, declared a climate emergency in 2021 and published a resolution confirming that and confirming what it was going to be doing. This led to the foundation of the Climate Change Committee of the Law Society, which I currently chair, and that led to the publication of the first ever voluntary guidance, we believe, anywhere in the world for the legal services profession. The guidance seeks to try to explain how we run our businesses and our practices of law wherever we may operate, but it also tries to explain how the law impacts every area, how climate change impacts every area of the law, whatever your specialisation. So explaining to our colleagues that it has a significant impact on asset values, on the insurability of asset values, on geographical risks such as flooding and forest fires, corporate reporting risks, climate disclosure risks, and the impacts for supply chain. We've been hearing about the development of ESG, and rather disappointingly today, the omnibus package was declared in the EU, which is actually a bit of a retrenchment on the provisions of the Corporate Sustainability Reporting Directive and the CS3D, the Corporate Sustainability Supply Chain Directive, which has actually been watered down. So it's only going to apply at the moment to the very largest organisations. But nonetheless, it sets a framework against which companies have to consider and report upon their climate impacts and the impacts of their supply chains, both up and down the supply route. For lawyers in private practice, lawyers working in areas that may seem that they are unaffected by climate change, corporate lawyers in M&A, in bonds or capital markets, may think that it doesn't affect their daily practice. So the purpose of our guidance was to explain how climate change touches all of these areas of law and affects everybody's practice, and no one can afford not to know about it or to understand the risks, the challenges, and the adaptation challenges that it brings. So our guidance was published. We discussed with our regulator, the Solicitors Regulatory Authority, whether it should become mandatory, and they weren't persuaded at that stage that it should. But it will be a subject that comes back for review. Since the guidance was published, we are now working on amending our annexures, which give real-life examples of how it may affect your work as a lawyer. And we are amending that to include biodiversity, nature, and habitat risk, which are all part of the sustainable development role that is very important for lawyers. We also talked about some of the ethical issues, the duty to warn clients and the duty to establish your retainer, whether you are advising on climate risks or whether you're not. There's been a lot of discussion about Scope 4 emissions, which are the liabilities and responsibilities of lawyers for the impacts of the advice they give. At the moment, that's just a discussion, but there is a likelihood that that will develop. There's also a discussion about the extension of the role of negligence, extending that where lawyers either fail to advise or simply miss the impacts of that advice on maybe the deal they're doing, the transaction they're doing, for example, the tax implications of what they're doing. So it's no longer really acceptable for lawyers wherever they practice to not understand climate change. In England and Wales, we are bringing out sector-specific guidance now for real estate lawyers, for those involved in the energy world and for those involved in M&A. And we anticipate that sector-specific focus will continue. Picking up on John's comments about education for the profession, the Law Society has set up a climate change hub on its website with materials for the profession. We're rolling out a series of training. We're also working up with other NGOs and organisations, legal organisations like the Chancery Lane Project, specimen wordings that are given freely to the profession, to help people really embed these principles and professional obligations in the work that they're doing. So there's a lot of activity. My only watchword, I would say, at the moment with the geopolitics and the way the climate is at the moment, There is a slight withdrawal. Europe was very much in the vanguard of all of this. Europe was very much pressing forward with the legal frameworks. It's not stepping away from those legal frameworks, but it's perhaps not pursuing them with the same vigor that it was a few years ago. I think it's impacted by geopolitical climate and by some of the concerns about over-regulation affecting the European market. Having said that, I think the direction of travel is set, and Europe, I think, will play its role alongside the other countries we've been hearing from the speakers today, and delighted to be on the panel with so many people really addressing these issues. So thank you.
Thanks so much, Caroline. I might just springboard from some of those comments and speak about what the work of the International Bar Association has been just in the last sort of year or two. Obviously, it's been active in this space for some time, having released a climate crisis statement back in 2020. We've heard a number of policies and guidance and work that's been done by the American Bar Association and the Law Society of England and Wales, and those and other initiatives and resolutions have all been combined in an online climate registry, which was launched by the IBA last year and is available now. And that includes a wide variety of materials, including reports on carbon footprints, resolutions, and is really quite a handy resource. But since then, the Bar Issues Commission, which is the forum within the International Bar Association for bar associations and law societies, that the BIC has established a climate change working group, which is an umbrella kind of group, which I co-convene, and has drawn together a diverse range of representatives from bar associations and the IBA's committees, a number of people present on the call on this session today, and includes a range of people with subject matter expertise, with educational experience, and with regulatory and institutional knowledge. The Climate Change Working Group, in fact, had a meeting just last week in Toronto at the annual conference, and it's determined to, its first two key work products are, the first is a climate engagement toolkit for bar associations to try and help lift the capacity of bar associations and law societies across the world, using as source material the work of some of the world better resourced bars, like in Australia and the US and the UK, and to build on roundtables that the IBA has been running at its bar leaders forums in mid-year last year and the year before in Bucharest and in Milan. That toolkit will provide precedents and example statements and feature explainers on climate science and its legal dimensions, how climate links there are within practice and the business case for engaging on climate change. And the draft toolkit is planned to be launched at the May Bar Leaders Forum in Prague. The second activity is one I think is going to be very interesting and picks up some of the things that John was speaking of, which is the development of a model curriculum on continuing legal education on climate change. And this is very much focused on building lawyers' competency through legal education and to help develop where they will need to have sufficient subject matter understanding and expertise to avoid the kind of issues that Caroline has raised, which is the potential of future regulatory or negligence actions for failing to having sufficient competency in this endeavour. And that work is being supported by academics and subject matter experts in those work streams and will be developed during the course of next year. And then generally seeking to highlight the work of bars and law societies, both just to identify across the world. Each organisation reflects the local experience of lawyers in their own communities. And so it is very helpful for us to, whilst we try to lift the capacities of lawyers across the globe, it's important to have the different regional perspectives and local perspectives. And so we'll also be forecasting that and showcasing that in the course of the coming year. So on that note, which I think is a hopeful note, I'll go back to Alessandra. Thank you.
Thank you. Thank you, Dominique. Thank you, Caroline. Professor John, it was really great to hear from you. And before I turn to our discussants for this session, just answering John's question, the Brazilian bar has been an observer to the UNFCCC, both at the federal and the state levels. So the federal bar has been an observer since 2009, the Rio Grande do Sul State Bar since 2023. I know the numbers and the years by heart because I've been involved in both processes of accreditation, and perhaps there will be more state bars following suit as well. So that's a bit of an update from our end to address John's specific question from earlier. So to kickstart our discussion segment today, I would like to invite my dear colleague, professor at UCS, Professor Leonardo. Leonardo is an expert in the law of the sea. So I would like to hear your thoughts on how the International Tribunal for the Law of the Sea set the stage with their advisory opinion for those that followed. Leonardo, the floor is yours.
Good afternoon, good evening, everyone. It's an honor to be part of the Climate Law and Governance Day, and in this panel on advisory opinions and climate change, chaired by my esteemed colleague, UX colleague, Professor Alessandra Lehmen and Dominique Hogan-Doran. I want to emphasize 4 key points regarding the legal aspects of the advisory opinion issued by the International Tribunal for Law of the Sea in 2024, as well the strategies for empowering legal professionals to advise clients. My first point concerns the fact that ICL's advisory opinion is already fostering legal capacities for states to mitigate climate change and reduce greenhouse gas emissions, especially in the maritime sector and naval industry, given especially vessels' emissions. The second point concerns the ICL's advisory opinion as a landmark decision recognizing the scientific fact of climate change impacts on the ocean. In my view, this advisory opinion refers to the Paris Agreement for 62 times, the UNFCCC 53 times, the Kyoto Protocol 8 times, and the IPCC report for 55 times. In my view, it significantly concluded that climate change represents an existential threat and raises human rights concerns, having referred to the need for stabilizing greenhouse gas concentrations in the atmosphere. My third point addresses climate financing, as ICL's offered insights into how finance flows align with a pathway towards a low greenhouse gas emissions and also to climate resilient development. According to Article 2(1)(c) of the Paris Agreement. Additionally, it required developed states to provide financial resources to assist developing states in mitigation and adaptation measures, according to Article 9(1) of the Paris Agreement. My last and concluding point addresses the need also to tackle jurisdictional and procedural issues raised by the ICL's advisory opinion, considering UNCLOS Part 15 on dispute settlement. We need, in my view, to be careful when analyzing the substantial obligations of states to protect the marine environment, as established in Articles 192 and Article 194 of the United Nations Convention on the Law of the Sea. However, and more importantly, lawyers have to adopt a more strategic approach to jurisdictional and procedural implications of these advisory opinions, especially concerning regional and international pre-existing institutions and agreements that confer jurisdiction to the international courts and tribunals such as ITLOS. In the Latin American context, for example, I am particularly referring to the historic and evolving Pact of Bogota, emphasizing the importance of interpreting Article 282 of UNCLOS regarding regional agreements and Article 31 of the Pact of Bogota. To conclude, in my view, we need to better balance substantive obligations with jurisdictional issues in ocean climate change litigation, and more specifically to interstate litigation, ocean litigation, which will surely directly impact many companies in the world. Thank you.
Thank you, Professor Leonardo, for your, as always, brilliant remarks. I will hand it over to Dominique for our next discussant.
Alessandra, I'll get you to take that because
no, that's fine. That's absolutely fine. No worries, Dominique. So next we have we'll hear from Mariana, our discussant. I cannot see her on the screen. Oh, yes, there she is. We'll hear next from advocate Mariana Herrero. Please correct me if I'm pronouncing this incorrectly. And so Mariana will tell us about the impact of the advisory opinions, particularly the Inter-American Court opinion in Mexico, and also the significance of the links made by the court between climate change and human rights for future regulation and corporate strategy. Mariana, over to you.
Thank you, Alessandra, and it's an honor to be here with all these brilliant climate change experts. I have to say I'm from Mexico, and this is relevant to what I'm about to say because we are a country of contradictions. This movement is one of contradictions because on the one hand, we have a private and financial sector pushing very hard to convey the message to private investors about the risk of climate change and how climate change risk is financial risk, and they need to start working differently and operate in a different way. But on the other hand, we have a government that is basically destroying our judiciary by changing completely how it works and establishing a system of electing all of our judges. We just had an election that basically the people voted for the Supreme Court justices and basically all other federal judges. And this causes uncertainty on how the new court will be able to understand the effects or how to apply the advisory resolutions from the court regarding climate change. We have had a very progressive Supreme Court in terms of climate, and the court had already recognized that the international agreements, including environmental agreements that Mexico forms part of, were equally valuable to the Constitution. So this allowed communities and stakeholders to challenge projects and government decisions affecting climate change to the court, and that's why the court was able to issue relevant decisions to protect communities with respect to projects. And climate change litigation in Mexico has always been against public policy laws or against authorizations for projects. That has been how it has worked. And obviously, a resolution like this would help strengthen arguments for plaintiffs being affected by projects that did not consider climate change effects to them. Now, we don't know how the new court will act or how will they rule with respect to these new cases, also because amendments to our Amparo law, which is the law that allows for the legal actions against violations to human rights and constitutional rights, has been modified to reduce the opportunities to challenge regulations and other authorizations. So I am afraid while we have good news in terms of climate change policy and the ICJ resolution in Mexico, we have a very uncertain scenario on how will this actually be able to be applied in real court cases. On the other hand, and on a brighter side, we do have a private sector and financial sector that is pushing very strongly for reporting, sustainability reporting obligations. We have mandatory reporting obligations, which includes scope 3 emissions, both for public and private entities. And again, a very strong financial sector for companies to start operating differently. So as lawyers, I think we have a responsibility to advise our clients not only with respect to the potential litigation risk if they don't include climate change risk in their operations and in their projects, but also on the fact that again, climate change risk is financial risk, and that if they don't start doing things differently, they will have reduced access to financial options, to less clients or trade partners, and because this is not gonna end, right? And then on the other hand, we have a lot of new regulatory changes going on in Mexico that will make operations more difficult in terms of having access to resources like water, and we have a lot of new environmental local taxes, and it will be interesting to see how the use of proceeds from these taxes impact the mitigation of climate change effects, which are supposed to be like that. And if the ICJ opinions help communities build cases against states that do not use the resources to mitigate climate change effects, but to other issues. So I wish I had a more precise scenario, but unfortunately we are living these uncertain times in my country, and what we need to do is just be very responsible lawyers and advise and try to find innovative ways for our clients to go about continuing doing better in their operations and projects. Thank you.
Thank you, Mariana. As a Brazilian, I can relate with the uncertainty. And before I turn to our Q&A section of today's session, I have two announcements. The first announcement is that our very first plenary of the day, in the first plenary of the day, we heard directly from Latin American judges from the three courts precisely on the subject of advisory opinions. So we've heard from Judge Leonardo Brandt from the ICJ, from Judge Kathy Ann Brown from the Tribunal for the Law of the Sea, and Judge Patricia Perez from the Inter-American Court of Human Rights. So if you missed today's first plenary, I strongly urge you to catch up. The recording will be made available in due course. And the second announcement is we were supposed to have a hard stop right now, but we, due to some scheduling changes, we have extra time to take your questions.
Wow.
And we'll have extra time to take questions from the audience. We have a couple of quite interesting questions that we would like to hear our panelists on. And the final closing plenary will start at 5:15 as opposed to 5:30. So I would ask you to join us for the closing plenary a bit earlier. So turning to questions, we have, as I said, a quite interesting set of questions from our audience. I will go over this set of questions, and then I will ask our panelists to choose which questions they would like to answer. And I would also, since we have extra time, I would also like to turn back to Luis, since we had to interrupt him earlier, to give him the opportunity to finish his thoughts on climate litigation, which seems to be a shared interest on this group and from our audience as well. So in the first question, we have Nusrat Zareen from Bangladesh. So Nusrat asks, what are the practical legal consequences for companies, particularly in low-income and climate-vulnerable countries like Bangladesh, as a result of the advisory opinions, and asks how these opinions might influence national law reform, corporate governance standards, and emerging climate-related litigation. And there's also one final part of the same question asking what role should bar associations and legal professional bodies play in preparing lawyers to advise corporate clients on these new obligations. We have another excellent question from Shukurat Oladejo from Nigeria, asking what is the legal implication for states under old bilateral treaties where climate obligations were lax or unspecified. We have a question from Robertina Hollenseed from St. Lucia, asking particularly with regard to the context of St. Lucia, where the private sector and micro, small, and medium enterprises and tourism enterprises dominate. How could recent international advisory opinions on climate change translate into practical obligations for businesses without creating compliance burdens that small companies cannot bear? There's also a question from Robertina in terms of support that bar associations in the Caribbean should receive in order to properly equip lawyers to guide local businesses. We have a question from Josué Simbo. There's no mention from the country Josué is watching us from, but he asks whether we should consider a deep understanding of the geographical regional position and indigenous knowledge as a tool for effective implementation of environmental regulations around the world. We have a question from Dr. Kishore Shankarderi from New Delhi, India, asking what sort of practical and theoretical challenges the legal profession may face in proactively advising clients on climate change matters. And finally, a question from Oladipo Fola Alade, asking what type of legal mechanisms are in place for regulatory compliance with regard to construction and renovation approval regarding emissions reductions So this appears to be a question related to licensing and permits specifically. So I would like to turn back to our panel, and the floor is yours to answer the questions that you would like to choose. And so perhaps since we have a question on litigation, and we had to cut off Luis Gustavo's brilliant remarks on particularly that subject, perhaps we should start with you, Luis, if you don't mind.
Thanks for that, Alessandra. No worries about cutting me off. I believe we had a very successful panel. I'll just cover the last part of my comments on the very interesting ruling that we had in Brazil. So I was commenting on the Instituto Preservar Herol versus Eletrobras, CGT, in Brazil. So we had a ruling from Justice Rosa in the courts of the Rio Grande do Sul that was handed on August 22, so just less than 1 month after the publication of the ICJ advisory opinion. And basically, she determined mandatory climate impact analysis and environmental licensing for thermoelectric power plants in Brazil. And she hugely relied on the advisory opinion from Inter-American Court of Human Rights, and also mentioned and referenced a lot the ICJ and the Intl's advisory opinions. What is interesting, that was my last remark, that besides imposing mandatory climate change impact assessment, specific impact assessment for climate change issues, that she also ruled on the liability indemnification for not complying with these laws. She said, this is of course a first instance ruling, but she established that there won't be indemnification for the past, but for the moment, or for that moment on, from 20 August on, if the climate change aspects are not incorporated in environmental license of their activities, there will be civil liability imposed to the companies involved. So this is a ruling that is very powerful and relies hugely on the advisory opinion. So just wanted to highlight, we're talking about a 98-page ruling. It's very extensive, very interesting. We can definitely share with you guys. And I hugely encourage you to take a good look. It also, it's a direct application of what Professor Patrícia Perrone Campos Melo said about Brazilian courts relying particularly on the Inter-American Court of Human Rights advisory opinion. So that was my remark, and I'll hand over to you guys to cover the very interesting questions that we had.
Thank you, Luis. Thank you. I'm personally happy to have been able to give you the floor so that you could conclude your very interesting remarks. It is indeed a very interesting decision. It was, of course, provisionally suspended by the appeals court, but on the merits, I think we're still going to see a lot of water under the bridge. So it's definitely a decision and the case to keep track of in Brazil. And there's also a second case which already incorporated the advisory opinions in their reasoning in Brazil, which is also the quite recent case challenging the proposed drilling activities in the Amazon. So this case also incorporates particularly paragraph 427 of the ICJ opinion, which equates failure from the states to regulate fossil fuel production and subsidies to an internationally wrongful act. So there's incorporation of this argument directly extracted from the ICJ advisory opinion as well. So it's definitely a growing field, and I think we are going to see several ramifications from the advisory opinions moving forward. So with that, I would like to turn to Caroline. Caroline will address, can you address, Caroline, the question regarding lawyers' education, and perhaps based on your practice as an ESG and climate lawyer, on the practical issues for advising on climate change?
Are you on mute, Caroline?
Yeah, Caroline, yes. We can hear you, but very faintly.
I'll lean forward. Is that better?
Yes, it's better.
Okay. Hopefully in the remarks John and I made, it gave some indication of the work that bar associations can do in educating the profession on climate change. But I think it has to start a lot earlier than that, with university undergraduate level legal training being a compulsory element rather than an opt-in element, because as I hope John and I indicated in our remarks, it affects all areas of legal practice, whether you're going to be a tax practitioner, a conveyancer, or an M&A lawyer. You need to know and understand the impacts, particularly of adaptation and of the sort of transition issues that are going to affect really everything in business law going forward, and the litigation risks as well. So what we are looking at the Law Society at the moment is working with our law schools, where lawyers go to do their postgraduate professional training, and having an essential and compulsory element on environment and climate change as part of that. My own firm now has a compulsory element on induction for everybody that joins our firm, whether you're a lawyer or whether you're not. You have an induction process, and I know a number of the leading law firms in London have adopted the same approach. Also, organisations such as the Legal Sustainability Alliance, the Legal Charter in London, now run active educational programmes, as does the Law Society of England and Wales. A lot of that is voluntary and involves lawyers showing an interest, as a lot of our younger lawyers and those starting out in the profession are very interested in this area and want to work in it. But of course, those in partnership level and slightly older in private practice are perhaps more immune. So we want to start training the profession young. So I think compulsory training as part of your legal education and qualification is going to be the next stage, and we're going to lobby hard for that in England and Wales, and hopefully through the Commonwealth countries. Lawyers not in private practice, lawyers in government, and lawyers in academia, I think already have quite an option to specialise in this area. But I think compulsory training right at qualification is going to be essential. Second part of the question, what are the difficulties of advising clients? Well, quite a number, because not all clients are willing and interested to embrace this area, and they all want to know what it's going to cost, to which my response is always, what is it going to cost not to do this? Which I think is the business resilience is a very important argument when you're dealing with a corporate client about this area. Corporate reporting, having legal and regulatory frameworks that require it are very helpful in persuading companies. What we see as one of the greatest challenges, a lot of our clients are global and are operating at global level, and therefore when they're doing their sustainability reporting, they need to comply across the world with the different regulatory jurisdictions. So that is one of the challenges when we're dealing with global organizations, is to deal with those different jurisdictional fronts. The other one is advising clients on liabilities that they might not want to recognise, that they might think we'll worry about that later. And there's also a fine line for the profession that we are not environmental lobbyists, we are environmental lawyers, and therefore there is a role ethically around our professional guidelines that for some reason people expect if you're an environmental lawyer that you're an environmental lobbyist. I think the two are distinct entities. You can be one in your spare time, but when you're at work, you operate under professional guidelines, which is why we issued the guidance to our profession in England and Wales. So it's not always plain sailing. Not all clients embrace their obligations, but I think we've got powerful tools now through the opinions, through things like the greenwashing rule, anti-greenwashing rules, and the threat of litigation, which I think has a very powerful dissuasive effect as well. So that was all I wanted to say.
Thank you so much, Caroline. And before I hand it over to Dominique, I just wanted to say that it's been an old battle of the Brazilian bar, the inclusion of environmental law in the mandatory curriculum. It's been an uphill struggle for the past several years. And also from my personal experience, I was also quite surprised when I sat for the New York bar to realize that environmental law wasn't a tested subject either. So we definitely have a long way to go on those terms. Dominique, please.
I just wanted to add a few comments to Caroline and also to respond in the context of responding to our questions from someone from St. Lucia and Bangladesh. I said earlier that I thought it was very important that we have the local, regional and also, of course, Indigenous contributions to the work of the IBA in developing materials for lawyers and bar associations to be able to help build competency and ethical guidance for lawyers in their practice. The Climate Change Working Group that I mentioned presently has representatives from the Bahamas and Samoa, so small island states, and also Pakistan. But we are looking for additional contributors. So Robertina and our other colleague, you're certainly welcome to reach out to us. But I think I just wanted to also reflect on Caroline's comment that the work of the IBA is not in an activist sense. It is very much a sense of providing the important ethical guidance to lawyers and also preserving the rule of law. And the work that is done to educate lawyers, future lawyers, and then through them the community is very important in the risks to the rule of law that is imposed by a warming world. So I wanted to sort of put the framework to the work that the IBA is doing, because I think it underlines the importance of the work. And I really ask everyone who's on this, and I know we've had a lot of people participate in the session, not just panelists, but also as attendees, to reach out to your local bars, reach out to your representatives, and get involved and support the profession. Thank you.
Thank you so much, Dominique. I think we are 7 minutes away from our hard stop. I think we still have time for 1 or 2 comments. If anyone else would like to take the floor and answer one of the questions that are asked by our audience. Patricia, please.
Well, yes, I would go back to the, there's a question on how the opinions are interfering with the judicial decisions. I think that we already spoke about that, but for example, the Brazilian Supreme Court already took into consideration the decisions of the Inter-American Court on protecting the environment. And based on these decisions, it ordered the government to reissue, to reformulate the public policy concerning the protection of the Amazon forest and also of the Pantanal forest in a structural law, in a structural litigation case. The Brazilian Supreme Court also considered some decisions of the universal system for protecting human rights in order to affirm the right of all Brazilians to have the government engaged in facing climate changes, and obligated the government to transfer a huge amount of money from a public fund to the Bank of Development of Brazil in order that the bank could finance some projects connected to climate changes. And in what concerns forest defenders, in Brazil, the majority of our GEE emissions are connected to either deforestation or the change of the use of the land. It's not connected with oil and gas. It's connected to agribusiness majorly. So this is also, I forgot, I lost myself. Sorry.
That's perfectly fine.
Yeah, I lost myself.
But yes, the emissions, our emissions profile is in Brazil is
sorry.
Primarily
Yeah.
linked to
Yeah.
deforestation and land use for sure. So we have 4 minutes left. Thank you, Patricia, for your remarks. And Dominique, I cannot see Dominique. I think she's no longer. Oh, there she is. So Dominique, if you have final remarks before we close our session.
I will certainly endeavour. I have moments of lucidity, and then I have moments of ferocious coughing. The impact of the International Court of Justice decision and advisory opinion and the other advisory opinions that we've discussed today very much underscore the importance for lawyers of understanding climate risk as a central component of their legal practice and as a risk for communities across the world. The urgency that is required by practitioners to become skilled and expert in this area has been underlined by this decision. Activities like this, these kind of climate law and governance days, are so important in bringing together experts from across the world, but also in providing guidance and information and elevating the importance of these insights. It's always been a pleasure for me. I live on the bottom of the world. I'm far away from the rest of the world. But what it demonstrates to us is how connected we are. We all live on the one planet. And I think also we're connected as lawyers. We have a desire to support our communities, to support our clients, and to support each other. And I think we're very fortunate to have had such excellent participants and panelists today to help us fulfill our own professional duties and also our duties to each other in the world. Alessandra, I might go back to you.
Thank you, Dominique. And on that note, I would like to thank everyone for a lovely conversation. This has been a fantastic session. I would like to thank my co-host, Dominique, our panelists, our stellar team of panelists today, our partners for this session. Special shout out to Advocate Emily Morrison from the IBA, who worked tirelessly to make sure we could properly prepare and convene this session today. And last but not least, the indefatigable team at CLGI and CISDL. Thank you, and I invite you to join our closing plenary in 6 minutes. Thank you very much. Thank you to our fantastic audience, and I hope I'll see you next year.